much lower than that now because in the last few months I pay some of the in-suite things. And also pay for the therapy for my kids every week. So it's dropping fast. And I used to have an attorney for my record. You could check it for my record because it's burning cash too fast. I have no choice. And so that's now considering all the factors what's ahead of me. I do think it's very important I get the legal consultation. And the only way to do that is to have some fee for that. I think it's a very reasonable amount I'm asking right now.
Okay. Sir, you are in charge of keeping up to date your income and expense declaration. The last one I have from you is filed very recently, 3 weeks ago, and it does list over $31,000 in an account, on top of which the court is sort of reserving your question. I am going to send it to SOC to discuss on August 31st because I want, before I can figure out whether there is a true disparity in access and ability to pay, which would trigger perhaps an order for attorney's fees. I need to know how much of everything you have access to. There's some sort of a community funds that may be divided if there's spousal support or child support, or no, child support would be the other way because they're 100% with mom. On top of which, I understand that there's been a request for what's called Watts charges, any housing payments for the fact that you were in the residence for a while, I believe. So all of that is going towards A, petitioner's ability to pay, which is a factor I have to look at, and B, I can't yet ascertain what your access to income is other than the fact that your most recent and very recent income and expense declaration has some amount if you would like to consult with an attorney first. So I am going to reserve, and I'm not denying your request yet, sir. I am reserving it and sending it to all be discussed at the August 31st Settlement Officer Conference. But I would encourage you to engage in that. I do see, sir, that you have not been employed for almost a year and a half now, according to your income and expense declaration. That's what you filed 3 weeks ago. You said if unemployed, date job ended, it says March 2025. So
correction. I didn't work after March this year, not 2025.
Sir, it's what you wrote. I didn't write this, you wrote that, okay? So regardless, it's not recent that you haven't been working. So the court is going to go ahead and at this point issue a seek work order as well. So that will be part of your conversation, so that once you come out, it may be that if you're asking the court to make a decision, if you cannot come to some agreement at your settlement officer conference, it may be that once it comes back to the court would begin imputing income. So I'm not imputing income to you right now. I am issuing a seek work order, which like I said before, means you need to seek employment and be applying to every 2 weeks to at least 5 different jobs with a list containing where you applied to, what date you applied to, where, and the name and contact information of the person you communicate with. You're going to send that list over to petitioner's attorney. You can send it once a month with 10 job applications listed per month. And then by the time you come back after the SOC, if we need to go to, if you need the court to decide anything, I may be imputing income at that point. Okay? So SOC, seek work order, and then hopefully, and September 15th is taken off calendar. Okay? Thank you.
Thank you. I'll prepare you.
Okay, line 4. Tianhua Katsa and Kitty Trim.
Hey, Judge, how are you doing?
Good afternoon. Thank you for waiting, to both of you. Okay, we are here on petitioner's request for is it for a protective order?
When I would get custody of my kids back.
Okay, one second. Yes, we are here on petitioner's request regarding changing the restraining order to add. Yes.
I believe I am allowed to
One
have
second.
photos and videos of
Wait,
my
one
own
second. Okay, given that the fact that we are discussing the domestic violence restraining order, the court is initiating.
self-defense,
Ma'am, just one second. The court is initiating the electronic recording to make sure that we have a record that's sufficient for any future.
Okay, are you gonna turn your webcam on?
No, because you're not on the web.
I thought you were on the webcam. I thought you were being monitored and recorded.
No.
Okay.
That's for when I have cases where somebody needs to be remotely appearing. But here, both parties are here representing themselves, and we are here again on petitioner's request to modify the domestic violence restraining order, which already.
How do I modify it to get my kids back?
One second. We're not here on your request, ma'am. We're here on the petitioner's request.
Yes, my kids
Right.
have said the father has been yelling at them every day.
Okay. Both Oliver and Emily are protected parties listed on the restraining order. That is still good. It expires April 2027.
I
And
did not do anything wrong to deserve losing my kids at all. It was self-defense.
do you know why you're here, ma'am?
He lied. I do not know why I'm here.
Okay,
You're
so
supposed to tell me.
that's what I'm about to explain, but you keep interrupting me. Okay. So the issue the concern that was raised is the videos and photographs that are being, there are video recordings and photographs, audio recordings, live streams that are happening during the supervised visits. And the issue, at least that was identified, is that the children's images were being used on social media alongside some more explicit material and adult content that you also post on your social media platforms.
There's nothing illegal going on. It's on Instagram, ma'am. It's for the whole world to see. I have photos of myself half nude in a bikini and lingerie, and then I also posted videos of my kids.
Right.
Nothing illegal going on at all. I heard he sex trafficked my kids.
Okay. So
You're not
ma'am,
gonna say anything about that? You're
ma'am,
leaving my kids in the abuser's hands?
we are, the court has no evidence of what you are saying. And right now,
There's
I
no evidence found.
this hearing is on the topic of the concerns that are raised in the petitioner's paperwork. I didn't receive any paperwork filed by you in response. However, you're able to talk, and what I hear you saying is confirming that what's on your social media, there are there is explicit content and adult content and sexually explicit material that you post alongside of pictures of your children. And that is not safe for your kids because,
Sorry, he posts drugs alongside photos of my children.
okay, so I don't have
You
any,
want to speak.
okay, ma'am, I don't have any evidence of that.
I can send you evidence, ma'am.
Well, we're here, again,
I'm saying I'm not doing anything
on
wrong.
petitioner's
I am
request.
not I have never trafficked my kids.
Ma'am,
I have never exploited my
this
kids.
is not criminal court, so I'm not saying that you have trafficked your children. I'm saying it is not safe given the kinds of people viewing your
I only have
platforms.
10 followers on there, whereas he has 3,500 followers.
Okay.
He posts his address,
Okay.
where he lives with the children.
Yeah, the court is inclined to make permanent the temporary orders that were signed in as, and to modify the restraining order to add those in. What I really want to talk about, ma'am, is that there was a temporary pause in supervised visitation pending your deleting the children's pictures off of your social media
I have
platforms.
never done anything wrong. That's why I did not delete any photos or videos.
Okay. This court is not criminal court. I am now making the orders.
You have no right to tell me to delete photos of my kids and my kids.
So if you don't have to necessarily follow the court's orders. I mean, you are supposed to follow the court's orders, but the way in which right now I can't enforce that is I am going to order that supervised visitation only resume once all the photos have been taken down. Once they've been taken down and you can agree to no longer be posting or videoing your children during the supervised visitations or posting any of their pictures on your social media, the court will...
the explicit photos. So he said I can have a separate account where I can post my videos of my kids, as long as there's no sexual material on that site. That's what he told me in the email.
Okay,
He
sir,
violated
are you okay with
the
that?
order by sending me a threatening email.
Okay, there is a restraining order against you, ma'am.
But he's not allowed to contact me. You said that. You said you guys are not allowed to contact each other. It's a no contact order.
You're not allowed to contact him.
I already got locked up for 3 days. For that, he deserves to get locked up as well.
He does not have a restraining order against him, ma'am.
There
So,
should be a restraining order against him.
well, just because you think there should be doesn't mean it is. So, sir, are you in agreement that as so long as there's not sexually explicit, it's not posted alongside, that she can post pictures if it's a separate account?
As long as it's separate, yes.
Okay.
As far as like the visitation, I was wondering if we could review that, or if it needs to be a separate hearing. Like, we've had 3 separate supervisors basically like deny and refuse service.
Because the
I have
fathers,
the written
he
report.
messaged them saying that
Please don't interrupt.
I have like the written report from the last one, but the last 2 visits were ended, and then after that they refused to work with us
It was
again.
not my fault, man. He told them not to let me record
Okay.
because he has something to hide. My kids were confessing about the abuse. The father was abusing them
Ma'am?
at home. That's why you guys don't want me to record.
Okay. I am going to make the order that supervised visitation is going to resume once the petitioner, once all photos are taken down. Okay, great. Once it's all taken
So
down.
when the next court being hearing me so I can see my kids.
Yeah.
He said as soon as I take it all down, I get to see my kids. So when will
As soon as you take it down, and if you can agree not to video them during your visits, the court is ordering that they are not to be videoed and that any pictures of them cannot be posted alongside any kind of sexually explicit or adult material.
I'm allowed to record my kids' visit.
No, I am ordering that they not be recorded.
I cannot see my kids. I am allowed
If you cannot
to record
agree,
my kids.
if you cannot agree, ma'am,
I'm not allowed to.
It's this court's order.
Whose order? Whose order?
Mine.
For what reason? I heard he
For the
paid
best
you
interest of the
$5,000.
children.
What's the best
Ma'am.
interest of the dog? Did he pay you $5,000?
Ma'am,
Did he? Yes
you're
or no?
not
That's a yes or no
interrogating the
question.
court.
Did he pay you
There's
$5,000?
been no, this court is fully able to be impartial and unbiased. And based on the information, the evidence that has been submitted regarding the posting of the children and the difficulties with recording them and live streaming them during their supervised visits on inappropriate channels,
Nothing
the court,
inappropriate, ma'am.
the court is going to require that you agree to not record the children during the videos. I will allow you to take photographs so long as they are not posted alongside any kind of, and all posts are taken down of them that are related to any accounts of yours that have adult or sexually explicit material on them. Do you understand?
I hear you.
Well, if you don't agree to those terms, I won't be ordering visitation. Those are just the terms of visitation. That is the terms of visitation. That is the order that the petitioner is going to provide any supervised visitation provider that contacts him. If you would like to contact a supervised visitation provider, you are going to be responsible, ma'am, for finding that supervised visitation provider who is willing to supervise your visits. A professional supervised visitation provider who is licensed and certified, and once you contact somebody who is willing to do that, that supervisor will reach out to the petitioner. It is not petitioner's job to find the supervisor. It's going to be your job to find the supervisor. That supervisor then is going to contact the petitioner. The petitioner is going to give them a copy of this court's orders as to what the terms are and what I am prohibiting to happen at those supervised visits, and then they can continue on the same schedule. Does that make sense? And that is going to be reflected in the protective order, which really means the court is adopting the temporary orders besides the no visitation pending hearing, because this is the hearing. Okay? Any questions? No? Okay, great. Then court is in recess. Those will be the orders. Thank you.